Good evening. To start out chapter 23 today, talked about uh, talked a lot about the major federal securities legislation. So went through a lot of acts concerning the federal securities legislation and their purposes to each one. Talked about the Security and Exchange Commission and the operation within, so creation and function, the structure, division of corporation finance, division of trading and markets, division of economic and risk analysis, the division of enforcement, the division of investment management. So the chapter also provided oversight of financial problems by regulatory agencies, risk-taking by large banks and non-banks, the too big to fail method, credit rating agencies, derivatives, and consumer protection, exemptions, and regulation of the regulators by court of law. There were more acts and cases to talk about. And then there was the stages in the securities registration process. So stage one was the pre-filing period. The prohibition was no offer to sell or buy securities may be made before a registration statement is filed. Stage two is the waiting period. So the SEC rules allow oral offers during this period, but no sales. So a red herring prospectus that disavows any attempt to offer or sell securities may be published. Then stage 3, the post-effective period, is registration generally becomes effective 20 days after the registration statement is filed, although effective registration may be accelerated or postponed by the SEC. Offer and sale of securities are permitted thereafter. Shelf registration was brought up. They had also talked more about the red herring. Private placement exemptions. And then there was, so these two subsections of resale restrictions and liability remedies and defenses under the 1933 Securities Act had given some visuals and examples.
I got it for free. He's in the video.
And then, okay, so moving on. The Securities Exchange Act of 1934, more of those were expanded upon. Proxy solicitations. There was remedies and defense strategies. So remedies make it a criminal offense to make an untrue or misleading statement or to engage in fraudulent acts or deceptive practices in connection with a tender offer. A tender offer is a public offer by an individual or a corporation made directly to the shareholders of another corporation in an effort to acquire the targeted corporation at a specific price. Moving on to chapter 24. So, really going deep on the antitrust law in chapter 24. Just beginning with trust, the Chicago School. More case studies, of course. So, then there were numerous acts and provisions to those acts provided in the text. And then exemptions, selective activities exempt under U.S. antitrust law. It provided several activities like the regulated industries, labor union activities, intrastate activities, agricultural activities, and then baseball, export activities, oil marketing, and then more specific ones along with these activities was a basis for exemption and an example with each activity. The per se standard, it gave more information on that, as we had learned earlier in the year, and in Foundations of Business as well. So got a little more insight on that. Monopolies and the exclusive dealing contract was an agreement in which one party requires another party to sell and promote only the brand of goods supplied by the first party. We all know a monopoly. So cross elasticity of demand and substitutability is if an increase in the price of one product leads consumers to purchase another product. Two products are substitutable, and there's said to be cross elasticity of demand. Okay, and then price discrimination, the primary line injury, secondary line injury, and the tertiary line injury. Really talked about types of mergers, interlocking directorates, and other antitrust statutes like the Federal Trade Commission Act of 1914 and global dimensions of antitrust statutes to sum up the chapter. Thank you for your time.